You're listening to Clearly Conspicuous, a podcast series brought to you by Holland & Knight's Consumer Protection Defense and Compliance team. Here at Holland & Knight, we have the working knowledge of how federal and state agencies operate and how courts address consumer protection issues to effectively work with our clients to address these issues.
Welcome to another podcast of Clearly Conspicuous. As we've noted in previous sessions, our goal in these podcasts is to make you succeed in this current environment, make you aware of what's going on, and give you practical tips for success. It's a privilege to be with you today. Today we discuss a timely policy issue, the Federal Trade Commission's current posture toward regulating artificial intelligence. We'll discuss recent comments by the Director of the Bureau of Consumer Protection, how the FTC has engaged with AI issues to date, and what this means for innovators, consumers, and the law. This episode will cut through the noise to give you clarity on where the FTC stands and where it might be headed. So let's start with the director's comments. Earlier this year, the FTC's Director of the Bureau of Consumer Protection, Chris Mufarrige, made headlines by stating that the agency currently has, quote, no appetite for anything AI-related, close quote, in terms of new rulemaking. Those comments came at an industry event focused on privacy and enforcement strategies. What he meant was straightforward. While the FTC retains authority to police deceptive, unfair, or harmful conduct involving AI, creating a broad, standalone AI rule through the rulemaking process is not on the near-term agenda. These remarks are consistent with his regulatory stance. Mufarrige has emphasized that the FTC should not create, quote, bureaucratic red tape, close quote, that might stifle the growth of the AI industry. So first, he is targeting conduct and not tech. The agency's focus has moved from judging technologies based on their potential for misuse to targeting specific bad actors who use AI for fraud, scams, or false earning claims. Then there's ordered liberty. Mufarrige famously stated that, quote, condemning a technology or service simply because it potentially could be used in a problematic manner is inconsistent with the law and ordered liberty. Close quote. Then there's avoiding overreach. He has criticized previous, quote, top-down regulatory approaches as overreach, arguing that the FTC should stay in its lane by enforcing laws as directed by Congress rather than acting as a roving legislature. Thus, this sentiment reflects a broader shift in emphasis. FTC leadership appears cautious about broad, proactive AI regulation, opting instead for toolkit enforcement grounded in established consumer protection laws rather than novel AI-specific rules. So let's talk about what the FTC has done on AI. Although general AI-specific rulemaking isn't a priority, the FTC has actively engaged with AI issues through enforcement actions and policy guidance that leverage its existing authority. Notable past and recent actions include the following. Enforcement based on deceptive and unfairness. The FTC uses sections of the FTC Act to pursue companies that misrepresent capabilities or harm consumers through AI-powered services. Then there are AI-related privacy and data practices. The FTC has taken actions addressing privacy harms tied to AI data use, such as alleged misuse of consumer voice and video data in training algorithms. Then there's voice cloning and fraud initiatives. Recognizing AI-enabled voice cloning as a fraud vector, the FTC's Voice Cloning Challenge encouraged development of safeguards against AI-enabled deception. Then there's Operation AI Comply and RYTR correction. In a high-profile case, the FTC originally brought an action against an AI writing assistant, Rytr, RYTR, based on alleged review generation abuses. Under new policy direction aligned with the White House AI Action Plan, the FTC reopened and set aside its prior order, signaling a shift toward requiring actual evidence of consumer harm rather than speculative risk. This pattern suggests the FTC is pragmatic and not doctrinaire in applying its existing statutory powers to AI-related conduct. So what we have here, folks, is shifting enforcement standards. A key doctrinal shift the FTC appears to be embracing is the distinction between theoretical risks and actual consumer harm. Rather than penalizing AI tools merely because they could be misused, the agency is focusing on cases where there's concrete evidence that the conduct is causing deception or injury. This emphasis on demonstrable harm reflects long-standing FTC enforcement principles. The agency's core mission is to protect consumers from unfair or deceptive practices, regardless of the specific technology involved. AI, in this view, is governed through traditional legal frameworks, not sui generis rules. At the same time, the FTC has made clear it will hold companies accountable when AI is used to mislead consumers or violate existing laws. So while broad AI regulation is not a priority, AI-related enforcement will continue under established authorities. So folks, what does this mean going forward? For innovators and legal practitioners, several implications stand out. Compliance with existing consumer protection laws remain essential, even when a product uses AI. Second, speculative, abstract harms are less likely to drive enforcement than real-world deception or injury. Third, businesses should be particularly careful about statements regarding AI capabilities. Misleading claims remain fertile ground for FTC action. And fourth, the FTC's posture reflects a broader regulatory philosophy: protect competition, protect consumers, but avoid stifling innovation with overly broad regulations. So that concludes our look at the FTC's stance currently on AI, a measured, evidence-based approach rooted in traditional consumer protection law and a practical recognition of innovation value. Thank you for joining. Stay tuned to further programs as we identify and address the key issues and developments and provide strategies for success. As always, I wish you continued success and a meaningful day. Thank you.
Thank you for listening to Clearly Conspicuous. For more information on our Consumer Protection Defense and Compliance team, visit hklaw.com/CPDC or email anthony.diresta@hklaw.com with any questions about today's episode.